Thank you very much for your interest in this important topic, drone attacks in international law. This is an issue of great concern, I know, to Americans, but really to people around the world. As we watch the United States try to persuade Russia to get into compliance with the international law on the use of force with respect to Ukraine, I know many of us are asking, wouldn't the U.S. case be so much stronger if the U.S. itself were in compliance with the international law on the use of force? And I believe that is true, that the U.S. would be more persuasive with respect to Russia and Ukraine, but so many other important issues to all of us. Today, the United States is in significant non-compliance with its obligations under international law with respect to the use of force when it comes to drone attacks beyond armed conflict zones. I want to explain to you why this is the case through looking at three different aspects of this question. First, I'm going to explain to you what a drone is, the kinds of munitions that it uses, but more importantly, the history of U.S. drone use, using drones to attack beyond armed conflict zones. And then I want to talk to you about the international law at stake, the law that should apply to areas where the U.S. has been carrying out these drone attacks, and the law that the President has contended applies, and will show that there are shortcomings in both areas. And then finally, I want to turn to questions of morality and also to counterterrorism information. Perhaps the law is out of date or doesn't conform with our most important moral principles or our strategic ideas about counterterrorism. I think after I present evidence to you in part 3, you'll agree that the current international law on the use of force is the best law for this problem of terrorism. It's the law the U.S. should comply with, and once having complied with it, the U.S. will regain a position of legitimacy and of authority when it comes to talking to other nations about their compliance under international law. First, to the drone and its history of use by the United States. Here is a picture of a Predator drone. The drone, its predecessors of the Predator were developed in World War II. They were first used for reconnaissance with a camera attached, and they have been used in all U.S. military engagements since the Second World War. So in Vietnam, we used drones extensively with cameras attached to surveil, to gather information. We used drones in that way in the Vietnam War, as I just said, in the wars in the Balkans, in the Iraq War of 2003, in the Gulf War of 1990-91. But in the year 2000, the United States equipped the Predator drone with two missiles, two Hellfire missiles. These are missiles that were first invented or developed for killing tanks. They are weapons of war. They are very serious munitions. Today, in addition to the Predator, the U.S. has many Reaper drones in its arsenal. The Reaper is a much faster drone than the Predator. It carries 4 Hellfire missiles, and it can carry 2 very heavyweight bombs. So we've moved ahead. We've moved to a much more lethal form of drone in recent years, and we're moving yet again to another generation of drones called the Avenger. What people know drones for these days are the fact that they can be remotely piloted. You can have individuals thousands of miles away, for example, at Creech Air Force Base in Nevada or in Djibouti on the east coast of Africa, operating drones that are in Yemen or in Pakistan. And in fact, the large number of our drones operating in Pakistan are operated by the C.I.A. out of their Langley headquarters in Northern Virginia. So that's the most famous thing, or the best known thing about drones, that they can be remotely piloted, that there is no human being inside the drone who could be shot down or taken prisoner or killed. We have drone bases much closer to the action where drones are being carried out for these purposes, but those drone bases don't have to have the operators of the drones at them. The individuals who are actually tracking suspects and carrying out the killings are often thousands of miles away. The history of the drone is really around these three countries, the history that we want to talk about today. Three countries where the United States has not been involved in armed conflict and yet has carried out thousands of attacks: Yemen, Pakistan, and Somalia. As I mentioned, the United States first put the Hellfire missile on a drone in the year 2000. It carried out the first killing operation with a Hellfire missile in November 2001 in Afghanistan during the course of the armed conflict that was ongoing there at that time. And the U.S. has continued to use drones in Afghanistan as part of the war on behalf of President Karzai against the Taliban. But in 2002, in November, the CIA operated a drone over Yemen that killed 6 individuals driving along in a vehicle on a remote road in Yemen. The operators were in Djibouti. The killings occurred in Yemen. 6 individuals were killed. The U.S. then used drones for killing operations in the war in Iraq, but in 2004 carried out the first drone strike in Pakistan, another country where the United States was not at war. In 2006, drone operations were carried out in Somalia, another country in which the United States was not at war. In 2011, the U.S. carried out extensive drone attacks in Libya. So the U.S. has carried out and used its lethal drones in 3 armed conflict situations: Afghanistan, Iraq, and Libya, but also 3 countries where the United States has not been engaged in armed conflict: Yemen, Pakistan, and Somalia. The non-conflict conflict situation is very important, but today we know, as a result of Edward Snowden's leaks on the NSA and our increasing understanding of how the National Security Agency operates and its collection of metadata, that there has been a problem with respect to all U.S. drone operations. And that problem is this: that the United States has been using metadata for targeting purposes, targeting cell phones, not particular individuals. And apparently this has been the case in Afghanistan, as well as the non-armed conflict zones of Yemen, Pakistan, and Somalia. This is highly problematic under any understanding of the law of armed conflict. Despite the illegality, which we'll talk about in more detail in a moment, the U.S.'s current plan is to expand its drone bases around the world. Even as we're drawing down from Afghanistan, we heard from Secretary of Defense Panetta in 2012 that the U.S. was thinking about putting drone bases in Nigeria, in Mali, to carry out further drone attacks in Libya, even though the armed conflict there ended in 2011. And perhaps even more worrying, the Obama administration is thinking about carrying out drone strikes or building new permanent drone bases in Central Asia, places where human rights are not observed, but the United States wants to make a deal for permanent drone bases so that we can continue attacks, presumably in Afghanistan itself and in Pakistan, even as our troops leave. So this is the story of the U.S. history with drones, past, present, and apparently future. What does international law have to say about that history? Well, the place to start with any discussion of this kind about the use of lethal force is with the most important rule that we have in international law. Let's face it, the right to life. It underlies all aspects of law, all reasons to have law. We fundamentally want to protect human life. We want people to flourish in their lives and in their communities. So we have to start with saying the law protects life. Article 6 of the International Civil and Political Rights Covenant is the article to which the United States is a party and the vast majority of countries around the world. It is part of fundamental international law that lives be respected. Now, Article 6 does say that a life should not be arbitrarily taken. And that arbitrary word is really referring to different situations, two different situations that confront our governments and other authorities around the world. Either they're trying to keep order and protect life in regular day-to-day peacetime situations, or their forces are operating on a battlefield in which there is greater danger for those engaged in the conflict and therefore greater right to take human life by legitimate forces or legitimate authorities. So we have to make a distinction when we're thinking about protecting the right to life. Is this an exercise of lethal force by a government in peacetime, outside, or a peaceful situation outside a zone of armed conflict, or is it on a battlefield? Some say, how can we tell? This is a new world order and it's very hard to tell or to distinguish between battlefields and non-battlefields. Well, okay, we might, some people may be persuaded by that sort of rhetoric, but in fact a committee that I chaired for over 5 years of the International Law Association looked at a variety of treaties, a variety of statements by governments and by the UN. We looked at extensive evidence of over 100 situations of conflict and violence, 70 situations characterized as armed conflict, and we were able to determine that within international law, there must be at least two sets of criteria for what is an armed conflict and what is not an armed conflict. Here they are. The existence of organized armed groups engaged in fighting of some intensity. If you're not looking at a situation with those two characteristics, then you look to the peacetime rules, the normal rules governing a government's right to use lethal force. And we're really talking about the police right to use lethal force. So let's talk in more detail about the normal situation that prevails around the world and prevails for the United States everywhere today except Afghanistan, where our troops are drawing down and ending their combat mission. In peacetime, in normal situations, the police are allowed to use some military force. They are allowed to use some lethal force. For example, if they see that a person's life is about to be taken by a criminal suspect, then the police may save that potential victim by using force first. And we're really talking about shooting, using hand weapons or a rifle to shoot that person. This decision of the European Court of Human Rights in the case of McCann in the United Kingdom ruled that in peacetime, governments may resort to force if absolutely necessary to save a human life immediately. And we all understand this from our day-to-day existence, that if the police come across a hostage taker or a very dangerous felon who has broken out of jail and is fleeing and will not stop so that he can be arrested and brought back to jail, they will use lethal force in those situations. But they will not ever risk killing a bystander. The United States is not a party to the European Convention on Human Rights, and that's the convention that this court looks at. But the court's statement in McCann is mirrored in these principles set out by the United Nations on how police should conduct themselves with regard to lethal force. And these are principles that the United States does adhere to and really is the standard police forces around the world adhere to. And this basically, in longer form, repeats what the McCann decision says. There must be a threat to human life immediately, a fleeing felon, a kidnapped situation, a hostage situation, before the police will resort to lethal force. And even then, if there are bystanders, for example, if the hostage taker has a weapon pointed at their kidnapped victim, but there are young children in the way of taking the shot to liberate that person, to kill the kidnapper, the police will not take that shot. We do not permit, in the saving of one life, the risk to other innocent lives, other bystanders around that criminal suspect. It's a very different situation on the battlefield, obviously, but this whole idea of civilians and not killing civilians, this applies only on the battlefield, not to peacetime policing. And that is why Asma Jahangir, the award-winning human rights lawyer from Pakistan, who was the UN Special Rapporteur on extrajudicial killing at the time of that 2002 Yemen attack, she concluded in her detailed report in 2003 that that attack was an extrajudicial killing. It occurred in peacetime. It was the use of a missile, not a rifle, to stop a fleeing felon. One of the individuals in the car was a criminal suspect, but the other 5, the U.S. knew virtually nothing about them. The killing of all those individuals in a non-armed conflict setting with a missile clearly violated Article 6 of the International Civil and Political Rights Covenant on protection of human life. And that is what Ms. Jahangir said in 2003. Sweden's Foreign Minister, Anna Lindh, supported Ms. Jahangir's statement. She also said it was a summary execution, and that is what it was. President Obama has tried to defend using drones on other arguments besides the argument that the U.S. is in some kind of worldwide armed conflict. He seems to understand that without these indicia, these criteria of armed conflict, organized fighting of some intensity in a particular location, using military force is simply unlawful. So he has made a number of other arguments, 2 in particular. He's argued that the United States is carrying out these drone attacks in places like Yemen and Somalia in self-defense of the United States, or he's tried to argue that we have an invitation or the consent of local governments in Pakistan, Yemen, or Somalia allowing us to carry out these attacks. Let me discuss both of those possible alternative grounds for defending this and suggest to you or argue to you that these are just as weak as the idea that we can use missiles in peacetime, non-armed conflict situations. First, let's turn to self-defense. And for self-defense, we have to start with the most important rule of the United Nations Charter, and that is Article 2, Paragraph 4. This article of the UN Charter, to which the United States and every other sovereign state in the world is a party, says that states will not use military force to carry out their policies. They all must refrain from the threat or use of military force. It is this article that the United States is saying Russia has violated in its actions toward Ukraine. There are, of course, some exceptions to Article 2.4. The one that the President has pointed to is Article 51. Article 51 sets out in the UN Charter when a state may, as an exception to Article 2.4's prohibition on the use of force, as an exception, when it may carry out force in self-defense. But look at this highlighted text. Yes, a state may carry out force in self-defense if an armed attack occurs. The 3 countries we're talking about, Yemen, Somalia, and Pakistan, have not attacked the United States. They are not in the process of attacking the United States. There is no armed attack of a significant kind that Article 51 is talking about to allow a right of self-defense. Well, what if there was an armed attack? What if there was a significant armed attack commensurate with, similar to what happened on 9/11, occurring from one of these countries? This is strictly hypothetical. This is not the basis on which the U.S. has carried out these attacks in the past. Well, it's not enough that there be an attack occurring to counterattack with a Hellfire missile on the territory of a country. That country itself, that sovereign state, must be responsible for the armed attack. Yemen must be responsible, not a criminal suspect in Yemen plotting in some small house or workshop that has nothing to do with the government in Sana'a. The government itself, because when you carry out a missile attack on a territory, you are attacking that state, not an individual or a small group. So there must be a connection, and that, again, first, there's been no armed attack from these countries. Second, none of the attacks that we can expect, the kind of criminal terrorist operations that the president has talked about, ink cartridges on a cargo plane that have been replaced with a bomb, these sort of suspicions and these sort of possibilities are not being connected to the governments so that we would have a right of armed attack on those territories. But even if there was a connection, even if the governments were responsible for significant attacks of the 9/11 type, as we have said that the Taliban were responsible in the case of the 9/11 attacks, and we felt we had a right to attribute those attacks to Afghanistan as a nation, you still have to meet a third condition before carrying out military force and self-defense. And that is that you can actually accomplish a defensive purpose, an anti-terrorist purpose, through a missile attack. And the persons that you kill, if you do kill bystanders, because now you're in the right of self-defense, so you could potentially have permission to take the lives of bystanders at risk, you have to not cause disproportionate harm on that country as weighed against the purpose of your military attack. So if your military objective is counterterrorism, you have to do a weighing that you will not disproportionately kill many bystanders in addition to those individuals you are specifically targeting. So 3 conditions for self-defense, none of which have been present in the case of Yemen, Pakistan, and Somalia. What about invitation? Well, first, let me tell you that invitation is a problematic basis for using military force on the territory of any country. We could do so as we did, for example, in the case of Libya, if the Security Council authorizes it. That's what we did in 2011. But in the case of Yemen, Pakistan, Somalia, we've had no Security Council authorization. And in addition to not having that basis, what kind of invitation could allow the right of another country to use military force on a nation's territory that will not interfere with the peacetime right of people to be free of lethal force except to save a human life immediately? Only if that country itself is engulfed in an armed conflict, is a scene of a civil war. For example, there's a civil war in Syria right now. The government and armed rebels are fighting each other, armed, organized, with intensity, and the government does have the right to suppress a civil war. If the United States were invited into that civil war by the government of Syria, it would have the legal right to join Syria. Of course, it doesn't want to do this because Syria has used terrible means and excessive force at times, and the U.S. wants nothing to do with supporting that government. But that scenario is simply not duplicated in the cases of Yemen, Pakistan, and Somalia. Yes, there's been a civil war in Somalia, but the U.S.'s drone attacks are first not at the invitation of any sovereign government in Somalia. It's barely had a government. And second, U.S. strikes have not been part of trying to bring peace and settle the civil war in Somalia. That would be the same for various moments of conflict and fighting in Yemen and Pakistan. The U.S.'s invitation, if it has had anything that's worthy of the name invitation from the elected leaders of those countries, it has not been part of suppressing violence and armed conflict of a civil war nature within Pakistan or Yemen. So the U.S. simply does not have a basis for all of these drone strikes that has been carrying out over these last 12 years in 3 countries. Well, perhaps the law is obsolete, outmoded. We've heard from some supporters of the administration's drone campaign that international law is out of date, or it's immoral if we can't carry out these drone attacks, if it's limiting U.S. operations in these three countries we're talking about today. So I've gone through various writings and teachings by some of our most prominent moral philosophers and ethicists, as well as an extensive study of the counterterrorism literature to understand whether international law should perhaps change. Maybe it is no longer in step with moral teaching or with what we really need to do to stop this terrible problem of terrorism. And in fact, I think the answer is the opposite. Some of the greatest moral philosophers and ethicists want us to preserve our rules on right to life, and they fear that these arguments in favor of drone strikes and in favor of bringing more and more lethal technology into our everyday life and everyday experience is undermining our respect for the right to life and our restrictions on taking life unlawfully, which is, of course, murder. Jeremy Waldron, truly one of the most prominent and respected moral philosophers in the world today, teaching at both Oxford University and New York University, has raised serious concern about these arguments to extrapolate from armed conflict situations or police situations to the situation of a terrorist suspect being in a remote part of a country or in hiding in a country, and trying to say that this represents a situation of armed conflict where we can kill this individual as if he or she were on the battlefield, or we can predict that the imminent threat posed by that person is much more immediate than, in fact, the facts allow. So Professor Waldron has said that if we go forward with this kind of exaggeration, this kind of extrapolation or stretch of the facts to fit our right to kill within them, we are risking unraveling our norms against murder. He is not alone in this view. The American Catholic bishops wrote to a number of high-ranking members of the Obama administration a few months ago, in May of 2013, soon before President Obama gave a major speech trying to defend drone strikes as self-defense or to respond to imminent threats. And the bishop said the United States really needs to comply with basic human rights law, comply with the rule of law, the rule of international law, in carrying out its responsibility to respond to terrorism and to suppress terrorism. If we do not respect current law, we are not acting consistently with the consensus view of what morality requires. And in fact, that was the very firm view of the United States with regard to targeted killing as recently as July 2001, when our ambassador to Israel said on Israeli television that the United States doesn't support targeted assassination, that killing people intentionally who are not on a battlefield is not commensurate with U.S. values and with U.S. policy. We did not support that. Perhaps these moral thinkers, perhaps U.S. policy was just hopelessly out of date when it came to what it takes to stop terrorism today. That's the other argument I regularly hear when talking about these subjects. And I suggest to you that both the law and the morality of using lethal force are consistent with what it takes to suppress terrorism. This is a terrible problem that we're unlikely ever to rid ourselves of. But we have a better chance if we commit to compliance with the law, which reflects our fundamental moral values, than if we just ignore them or if we try to put forward a case that what we're doing is lawful and moral when in fact the facts do not fit the law. So I would suggest to you further engagement with recent testimony of some of our top-ranking intelligence officials. General Clapper, for example, has said, when he was asked the straight-up question, is al-Qaeda on the path to defeat through 4,100 deaths by drones? And the answer from General Clapper, no. And his successor, Lieutenant General Flynn, agreed. They are not on the run. They are not coming to an end. Members of Al-Qaeda are spreading. The membership is growing. We have caused a bigger problem through drone strikes and through our other policies toward counterterrorism than I would contend we would have today if we had followed the law. And that's, in fact, what was predicted by the RAND Corporation, a defense intelligence analysis corporation that's been around since the Vietnam War. And they said that the way to respond to the problem of terrorism is to follow the law, is to get young people and organizations involved in the political process, to support the economy so that people have jobs and they are not lured into these kinds of charismatic organizations. But most of all, their study says clearly that military force, the kind represented by the Hellfire missile or the drone, have not led to suppression of terrorist organizations over time. And in fact, I think most of you listening to this talk today understand that the United States has engendered terrible hatred in the countries where we are using drone strikes. In Pakistan, the United States is the #1 most hated country. And that is a country that has suffered terribly from terrorism, where we should be in cooperation with the authorities, supporting a criminal justice system that can handle the problem of terrorism and terrorist organizations, where we are supporting the economy so that there are jobs and there is prosperity and there are alternatives to a life with a militant group. Instead of doing those things, we have used our precious funds to attack and attack and attack. And the result has been, as you see in these various pictures, very familiar, I'm sure to many of you, that the U.S. is seen as the lawbreaker, as the country that the Pakistanis want out of their own nation, not present, not even for criminal justice cooperation. So in the view of myself and of many, our drone attacks have been counterproductive to building those cooperative relationships we need to finally end the problem of terrorism. We hear regularly about the fear of people throughout the 3 countries I've just named, and sadly, I fear in countries in the future where people wait in terror for the next drone strike. The report by Amnesty International, represented here in this picture, is all too real. This is not an exaggeration of how people in these countries feel. They feel that they are being unfairly, inappropriately, unjustly threatened with drone strikes, with drones flying overhead constantly. This is going to be a growing problem around the world for many of us, not for people in places that Americans may think are remote, because every military in the world is interested in getting drone technology if they don't already have it. There are conversations going on now in military departments around the world that we want to use our drones the same way the Americans are using theirs. We want to use our drones to target the people that we think are our enemies, regardless of what international law says, regardless of what a court would say if there was a trial of this individual. Use Hellfire missiles, blast them out of existence. That is the terrifying future world that we could be looking at. Or we can look at a world in which international law prevails, in which the clear distinction between using military force only on a recognized battlefield, where organized armed groups are engaged in intense fighting, and leave to the police and law enforcement measures responding to the problem of terrorism outside armed conflict zones. That's how the United States does it within our own borders. Why don't we extend that same courtesy, that same respect to other countries, and again become a leader in international law, a leader with respect to persuading others to comply with the international law on the use of force. Use force only when truly necessary and permissible under the rules of the UN Charter. I hope all of you listening to this talk today will contact your elected officials, will contact the leaders of your faith, will contact your neighbors, will have this discussion, and will ask that the rules be complied with, that the United States regain its stature as a country in which the rule of law prevails and not the rule of might. Thank you so much for your attention, and best wishes.